with this section. Because the claim says in organic software. It is unreasonably broad. Similarly, many examples of the claims are base. Base which rather comprises organic, inorganic bases all within the scope if you look at the language of the claim.
I mean, like I said, the answer is there in the question itself. In the sense that, you can, that's why, it's a two-edged word. When a patentee during March when he tries to get the broadest possible claim, and then he comes back to, on later, this is part of the claim and then rename. It's straightforward. It's not going to be interpreted such that to preserve its enablement. Its scope is defined and has to be enabled for the entire scope. Okay, I need any more questions.
Hello, my name is Garima and I am a patent agent. I am a computer engineer as well. My question is somehow related to what Vidya asked you regarding the limit line. There is no line drawn for technical advancement for software claims. So as Robert said that software patent should be drafted as a story, like there is a problem and we are giving a solution. Basically, software is a set of instructions. Like it is a step-by-step method. We don't claim the program, but we claim the steps, the methods. So my question is related to drafting of claims. What should be the best approach? How do we draft software claims which have only steps and there is no novel hardware feature? Like should we include words such as terms like server? Should we include memory? How do we draft software claims?
My personal opinion at this point is that you bulk up your algorithm in your specification by putting all of it in there, and then you functionally claim it.
Functionally, you mean all these steps, like the first step is, like the second step is dependent on the first step?
Just make sure you have structure in your specification. You need to have structure. You need detailed structure in your specification. And I think you can be safe.
Okay. Basically, in software patent, when we get rejections or objections from the patent office, we generally get rejections like the steps that you have given is done by a general computer. A general processor can follow these steps. So how do we counter such kind of objections?
So the starting point is hardware, but that by itself won't be enough. As an example, I was talking to one examiner regarding a one-on-one rejection, and he told me that he had an application where the client or the applicant amended the claims to include the individual software kernels into the claim and to show how the kernels were communicating with each other. And in his opinion, that the claims were now directed to a showing it. It wasn't simply just an abstract idea. It was a technological solution. The claims were more technical in his opinion. I don't think that example would work for every particular application. I think it really comes down to the end of the day, Bob had mentioned, is that the specification, of the claims need to mention the story of what is the problem you are trying to solve. And the problem is to cater to that because of the existence of computers, and as computers are becoming more and more advanced, they've created more and more technical problems that need a solution. So although you have claims that are directed to general purpose processors and they functionally list steps, the argument to be made there is that the claim as a whole is directed to a solution that solves the problem that's disclosed in your specification.
All right, thanks.
Mr. Arthur, you have an insight in that practice. You seem to be a little bit broader on the computer program claims than any other jurisdiction.
So I'm not a computer science, but my recommendation is please write the specification in detail as much as possible. So otherwise, if you focusing on the Indian patent law and then excluding some topics or some detailed parts, that patent cannot be granted in outside of here, countries like Japan, Korea, China, everywhere. So you need to disclose everything in detail.
How much does prosecution history and claim amendments influence the claims and infringement action?
So, because we don't have examination, prosecution history would be obviously prosecution history in foreign countries. And you look for you'd have to have a fairly clear statement by the applicant or the opponent of the applicant that could be used against them. My experience is that mostly those silly statements aren't made, or they're made in clever ways. So I think what you tend to find with us is that there is an argument to be made which says, yeah, in the US the claim was limited, but that's because the US law is completely different from South African law. And similarly in Australia there was a limitation, but that's because the requirements were different. So that barring a very clear disclosure or statement, your prosecution history is not going to help you tremendously. But it certainly is something that we look at when we deal with these things.
Yeah, prosecution history is a very important part of the to know what is a claim language. So, but I want to ask to my colleague to answer that question.
Hello everybody, I'm calling from Mr. Hattori. My name is Kazuya Tanzawa. And in Japan, there is a file wrapper Aristotle. And especially when you make a counter argument to overcome this rejection, such as lack of inventive step or lack of novelty, to distinguish from the prior art, such counter argument may be used to against you when you use the patent in litigation phase. What is the meaning of the claimed word, claimed terms? It may be construed by the prosecution history. Prosecution history. And of course, you intentionally exclude some features by the amendment. Such amendment will exclude such features from the scope of claim. And the situation is same in the doctrine of equivalence. Unlike in the FESTO case, there is no complete bar in Japan.
This question pertains to how claim amendment, or prosecution history affects claims in an infringement action. So since this is an infringement action, that means we're now outside of the USPTO. The broadest reasonable interpretation doesn't apply. We apply the Phillips standard, where we apply the customary and ordinary meaning to a claim term. Under the Phillips standard, it categorizes evidence as intrinsic evidence and extrinsic evidence. So intrinsic evidence is going to be the language of the claims itself, the specification, and the prosecution history. Under Phillips, the intrinsic evidence is used first before you resort to extrinsic evidence. And examples of extrinsic evidence include expert testimony, dictionary definitions, or any kind of extraneous document like a publication. So under Phillips, the preference is to use intrinsic evidence, and to the extent that you can't resolve a claim term, you have to resort to the extrinsic evidence. So within the intrinsic evidence, you have the claims, you have the specification, and now you have the prosecution history. So within that intrinsic evidence, it's going to be ordered. First, you're going to look at the claims themselves, and to the extent that the patentee acted as their own lexicographer, or you could resort to the specification. After you look at the claim language itself, then you can resort to the specification. So after the claim language and after you look at the specification, then you can look at the prosecution history and resort to that. So within the intrinsic evidence itself, it's going to be claim language, specification, and prosecution history. And to be quite honest, the prosecution history, any post-claim proceeding, infringement, it's going to be, any attorney will go through every single line with a fine-tooth comb. And the question is how strong will the statement of the prosecution history be helpful in terms of interpreting the claim? And what you got to look for a clear admission, a clear disavowal of claim scope. If you don't have that, then you could still use the prosecution history in trying to interpret the claim, but without that clear admission or disavowal of claim scope, it may not help you out, or it may not be given as much weight as you'd like it to be given.
Let me ask you a follow-up question. Is there a hierarchy in prosecution history stuff? For example, statements made in the prosecution history of this very patent versus statements made in a parent application versus statements made in a cousin sister application or in a foreign application or in a different application by the same inventor on the same subject matter?
I love my answer, and it depends.
Like a true lawyer.
Absolutely. First of all, judges have quite a bit of discretion in the way they value different types of information. But you can naturally determine where you think more high value. Of course, the closer to the application itself, I would think would be the more valuable information. But as I said, the judge looks at all the totality of the information presented and makes their determination based upon that. So the answer is it depends.
That's why it's quite important that if you're, a lot of the practitioners in India that are looking to invalidate, in pharma side, it's important to look at applications that are, related, same inventor, maybe a different application, same inventor. Comb the entire landscape, and there will be plenty of useful information all over the place. And now, with increasing standards after limelight, if you can show that, the same type of property value, if you do it with a different equipment, you're going to get a different answer, and that determines whether you infringe or not. That's enough grounds for invalidating on Section 112. So it's important that you comb the entire landscape for similar patterns and do search on the inventor's name, find as much as possible, and what are those statements that are made in all kinds of foreign jurisdictions. So prosecution history can be quite important on the patent enforcement side of things. Now, do you have any questions on this topic? Yeah.
That the patent has undergone claim amendment during prosecution history before it is allowed. If I understand in US particularly, once the claim has been amended, then doctrine of equivalence is not applicable. Am I right?
Yeah, the first so, yeah.
Is that so in Japan and South Africa as well?
We don't have a case strategy, as we said.
My question is, if during prosecution, whatever applicant has put in claim at the time of filing an application, it undergoes amendments, the final claim which is allowed is limited vis-a-vis what it was applied for at the beginning. In US, for infringement purposes, doctrine of equivalence is not applicable. Claim scope is whatever has been defined allowed eventually. Is that so in Japan and South Africa also? Applicability of doctrine of equivalence in amended claims.
So you can have that so we can have the doctrine of equivalence. We can a little bit broader define. We can still keep the doctrine of equivalence.
Even if the claim is amended to exclude a particular element that you're now bringing equivalent.
Yeah, of course we cannot use it excluded particular points, but still we have some broader scope of the claims.
So, in Japan, what is the philosophical reason behind having doctrine of equivalence in the first place? Why do we even have doctrine of equivalence?
So, like, if there is a range from 1 to 10, still there is a 10.05 or something. That includes the scope of the claim. That is doctrine of equivalence one example. So even if we exclude 11, so still we will have 10.4 something.
Any more questions on this? Okay, I'll go to the next topic. There are all these different types of claims which kind of are becoming obsolete in the United States, many of these types, even though they are available on the books. I'll direct this question towards other jurisdictions. Jepson claims, one-to-dependent claims, Swiss type claims, all of this. What is the status of these types of claims in your jurisdiction? Start with Golden.
So we traditionally allowed most of these types of claims, all of them, Swiss type, etc. I think though that following the EP trend, the European trend to not allow Swiss type claims to more narrow, you might find that being applied in South Africa. But how exactly they would do that, I'm not sure, because we have so many Swiss type claims in existence in current claims that would have to be worked out. So my guess is that you're not easily going to see our courts just tossing out claim forms just because they're not in vogue in Europe anymore. I think you're probably safe with any previously acceptable claim forms.
What about product by process?
I think provided that you could reasonably interpret them, that's fine. I don't think you're going to have any difficulty with that. I wouldn't see any personal difficulty with that.
For a product by process claim, for novelty, would both the product and the process have to be novel?
Probably not. I think you would, if your product, if your process was sufficiently inventive, novel and inventive, the product produced by that process would be perfectly patentable. I don't think you're going to have much difficulty with that.
And during infringement, do you have to show both the process and the product to be infringing?
You would certainly have to. You would have to have. I think you would certainly have to have both the product infringing and the process infringing. Absolutely. And I qualify that by saying if it's a known product. So we have the proviso in our law that if it's a new product that's being produced, then it's assumed to be produced by the patented product, by the patented process. So the counter assumption then is that if it's not a new product, you would have to prove the process being used. So yes, you'd have to prove the product is the same product and the process is the same product, is the same process as made.
I mean, are these claims used, practitioners who rely on product by process?
They are used. Again, I struggle to give you a straight answer simply because we don't have sufficient recent litigation to say this is the way to look at them. And we don't have an examiner saying I'm not accepting this. So you actually have to rely on what the Act says, what's going on in Europe to try and arrive at a decision. But again, I think our courts are tending to be very reasonable to the patentee, possibly overly so at this stage.
So, in Japan, what is the preference for the Japanese patent office regarding all these types of claims?
Yeah, most of the claim style is a lot like European style. Japanese claim is okay, and C style is also okay. C style is still as method claim, pure method claim. And we have currently a new decision from the Supreme Court regarding product by process claim. So the Supreme Court decided that the product PVP claim should be rejected as a clarity requirement. So now we need to modify or amend the product by process claim to not saying the process as such. Maybe we do not have the how the scope should be, and the Supreme Court doesn't say the scope of the claim, but maybe broadest broadest claim should be allowed. So not related to the process, but also other process can be defined in the product by process claim. So only one thing which product by process claim allowed is there's unavoidable reason to say there was the method, the step of producing the product. That only one way to say to keep the process in the process product.
I will skip your in the fact that you have to decide. So, if there are any comments on preference by the
Product by process claim, the process is given little weight in the United States. So, that's simple. Adjusted claim is an improvement claim. I don't see it very frequently anymore. You may want to use it in a tight area where there are many things you want to show where your improvement is, but I don't see them very much anymore. So it's basically standard claiming, which is the way things are going to happen in the United States.
Yeah. Multiple dependent claims, pretty much everybody avoids in the US. It's very expensive. You don't gain anything by having. So when we get applications that are funded from other jurisdictions, one of the first things we do is to take off all the